Just want to welcome everyone here. I'm glad you could join us. It is my pleasure and honor to have you here. And today's topic is early stage fundraising from the legal perspective with Leslee Cohen of Allrise Legal Counsel. Leslee will give us a presentation and provide us with a layperson's explanation of the securities laws that apply when a business is considering a raise. Thursday, June 30th from 12 to 1, we'll welcome Leslee back for an AMA. So please join us then and bring your burning questions. I'm sure you'll have lots after this presentation. And we will also be posting the recording in our platform in case you would like to revisit it. So please keep yourself muted and feel free to drop in your LinkedIn links into the chat if you'd like to stay connected with others in the room here. And before we dive in, a very brief word about the fourth floor for those of you who are not currently members or are not don't know much about us. So at the fourth floor, we help women founders access funding and growth opportunities by leveraging advisory and governing boards and our backroom investment club. We're hacking the system and providing a place for women to initiate and advance for-profit board careers, earn equity, and invest. And we're doing this by tapping into the under-leveraged value of women entrepreneurs. So if you're not a member, consider joining us and or registering for our platform tour so you can see what we're all about. And our next board boot camp, which will happen in September. And we'll be putting these links into the chat for you to access. And so that is enough about us. Let's get to the point of today, fundraising. It is my absolute pleasure to introduce you to Leslee. And I'm going to turn it over to you now, Leslee. Welcome.
Terrific. Thank you. Thank you for having me and to everyone for being here. I'm going to start with a little bit of just an introduction of myself and my background so that you understand the perspective that I'm coming from. And then I'm going to talk about a lot of complex things. So just to reiterate, please come back. We're not going to do a Q&A at the end of this. We're going to do it on Thursday. So please come back with any and all questions. I'm excited to dive further into whatever is most important to all of you. So I went to law school at NYU and graduated and stayed in New York and practiced at a Wall Street firm for 6 years. And I was doing all very large publicly traded company work. So IPOs and mergers and acquisitions for huge companies, very sexy and exciting, but not conducive to having a family and being around for them. So moved back to Chicago, and which is where I grew up, and I spent 13 years at a 100 lawyer firm. So I'd say big. I guess in Chicago they say mid-size. But I was doing the same kind of work for microcap publicly traded companies and then small privately held, large privately held businesses, helping them with their money raises, with their day-to-day contracts, and with mergers and acquisitions. And then in 12 years ago this August, which is crazy because most of you are probably founders, I am too, I left with a partner to start my own firm and bought him out last year. So now we have 6 female attorneys and 2 female paralegals. The firm is called Allrise Legal Counsel because we're about helping startups and women rise, all rise together. And so right now we're focused on helping startups. So that the same laws that apply if you're raising $500 million apply if you're raising $500,000 or $250,000, so or less. So really just it's obviously very different market terms, but the same laws. And so when I started the firm and I started going out there trying to, figure out where I fit in the marketplace, I pretty quickly realized that most of the work for companies raising money is done by really large law firms at really high prices. And so I saw a place for, our small boutique firm in that market. And started working with startups and getting involved in all different incubators and accelerators and speaking and mentoring. And that's really the focus of the practice today. So we can jump into the important material. I just wanted to, here we go, screen share. Just wanted to let you know, give you a perspective on where I'm coming from. So let's see. Not letting me go to the next slide. Let's see. Sorry about that. There we go. Okay. So overview of what we're going to talk about in the next hour. We're going to talk about the different kinds of rounds that you can raise, and sort of the typical order that those fundraising go in. We're going to talk about the different kinds of securities that you would sell in those rounds. And then we're going to talk about the laws, and I'm going to tell you about these laws from a layperson's perspective, so they're not all confusing, that apply. And then what documentation, in my opinion, is best for you to actually need in order to protect yourself. And then after all of that, we're just going to do a little bit about divvying up founder stock, incentivizing early employees and contractors with equity, and that's the main gist of the presentation. The reason that I started doing this, offering this presentation, is that a lot of my startup clients would come to me and they would say, you know, I went to one lawyer and, you know, let's say the person who lived on my, you know, on my left, and she is a big firm lawyer, and she said, oh, you're selling to friends and family, and you know, it's your very first equity round, and you're raising like $250,000, but you're selling a security, which is true, and you need a private placement memorandum, and it's going to be $50,000 in legal fees, and you know, and they're like, what? I can't do that as a startup. And then, you know, they're panicked, and then they go to the lawyer who's on the right, who lives on the right, and he's like a, you know, general practitioner, does small firm, does like wills and trust and estates and some buying and selling of small businesses. And he says, oh, that's ridiculous. You're not selling a security, or, you know, you're just selling this, you know, print out a form of convertible note from the internet and give it to your investors, you're fine. And that's not right either. So what I want all of you to walk away from after today is an understanding of like what does apply and what should you need to worry about, and when is your lawyer like way over lawyering or way under protecting you. So let's start with the different kinds of raises. So the first thing you think about when you're really early stage is if you're lucky enough to have friends and family who have the money to invest in your company, that's always a great route to go. And then, you know, if you don't, or if you have some kind of connections with what's called angel investors or sometimes seed round investors, you know, this is typically when you're raising up to $1 million. Those are sometimes your two choices, and people say like, why would I go with one versus the other? And I'll tell you some of the benefits and detriments of each. So, you know, friends and family usually are much less sophisticated. And so, you know, one of the issues is that they're unfamiliar with a SAFE. And we'll talk about a SAFE that is the most common. It's called a simple agreement for future equity. And it is the most commonly used fundraising mechanism, or, you know, security that's being sold today in your early round of your very early rounds of fundraising. And so, you know, very often friends and family will say like, what is that? And we'll talk about what it is, and it's a great document, especially from, I think, the company side. But it's a little complex, and it's a little, you know, I was actually telling my 84-year-old dad about it, who's a lawyer, the other day, and he's like, why would anyone invest in that? And so you get a lot of pushback if you have friends and family who hire a lawyer who's never heard of the SAFE, or, you know, just really aren't sure what it is. So that's the downside to that. They also may be unaccredited investors, and we'll talk about what that means. And so that's unaccredited investors. A lot of times later on, when you're doing later rounds, your more sophisticated investors don't like seeing non-accredited investors on your cap table. And so there may be some pushback there. Also, the courts are really protective of non-accredited investors. So it's basically people who don't meet certain wealth or income standards. And so, you know, if someone loses their investment in your company and goes to court and tries to bring an action against you, the court's going to be much more, understanding and sympathetic to a non-accredited investor. So that's another reason to be a little careful of that. And then, the other thing is that with friends and family, they often don't have like the sophistication to add value to you. They're just giving you their money. And so, that's a great thing about working with a more sophisticated angel investor, is that they often have strategic advice to give you. They have, they have partnerships they can recommend, contacts that they can give you. They've done a lot of this. They've seen what works and what doesn't work. They're accredited investors. I would say the downside is they're going to be much more likely to tell you what the terms of your raise is. Whereas with friends and family, it's more like you're going to have your term sheet. You're going to say, this is the terms I'm offering you, period. There might be a little bit of negotiating, but not as much as, with an angel. So there's, you can see there's good and bad to both. So let's talk about the different kinds of securities that you could sell when you're raising your first round of capital. So again, typically this is up to $1 million. I have to say in the last couple of years, it's crept up to, I've seen these, we're going to talk about convertible notes and then safes lately, and I'm talking before the new talk of recession came around, going up to $3 million. But I think, I'm sticking with the numbers that I have now, because I think given the pressure that startups are feeling in the marketplace, that's probably going to come back around to these types of numbers. So typically in the beginning, what happens is, clients will come to me and say, okay, I'm ready to sell, I need to raise $1 million. But like, how do I know how much of my company to give up? How do I know how much my company is worth? It's brand new. And the answer is, it's a very difficult decision to, it's a very, very difficult thing to answer. And for some reason in the market, startups are typically valued at 1 to 2 million. But what's happened in the last, 10, 15 years is that these new convertible securities came around so that you don't have to put a value on the company. So what you do is you sell to your investors either a convertible note or a safe. And what that does is avoid having to put a value on the company. And so what you do is you say, I'll take your money. And for years and years, it was convertible notes. And in the last 5 years, and I'll explain why it's more of these safes. But what you say is, I'll take your money, and instead of giving you back X% of my company, I'm going to give you a promissory note. And the promissory note is going to be due very short term, usually 1 or 2 years. And what it's going to do is convert into, when you raise your next round of financing or you sell the business, it's going to convert into the same securities as that next round investor gets, or an amount of the sale proceeds. But because you invested early, you're going to get better terms. You're going to get a discount to the price that next round investor or buyer of the company pays. So it's a convertible instrument, and again, avoids having to put that valuation on the company until there's a valuation, because there's a preferred financing or a sale of the company. Now, the couple caveats. One is that if you're raising money and you're like, this is my business, I want to run it for the rest of my life, and I just need a little startup capital, do not sell convertible notes or safes to investors, because these are instruments that help companies and are an appeal to investors who want, who want some kind of more of a quick exit, who want to know that you're building a company to sell or to take public, in somewhat of the short term. So there's these convertible notes started to be used, and what happened was, and this is why we're going to get to safes. What happened was that, as you probably know, if you're a startup founder here, that 2 years is a really short period of time in the lifetime of a startup. And so these notes started becoming due. First of all, there was a huge amount of negotiation. Do the notes convert? automatically? Do the notes convert? Is there a potential for repayment of the note? Is there a vote of all the note holders and the majority decides whether there's a conversion? So there was a lot of negotiation, which led to really high legal fees and time. And when you're raising money, you want the money. And then the other thing that happens is 2 years comes around and the company still doesn't have the money to repay the notes because it's a startup. And so then you have to renegotiate the terms. You've got pissed off investors who are like, I thought I was getting my money back in 2 years. And so this organization called Y Combinator came up with the concept of a SAFE, again, simple agreement for future equity. And the beauty of a SAFE is that there's no negotiation. There's 2 terms in a SAFE. There is the discount, which applies on conversion of that SAFE into the next round of capital or a sale of the business into the proceeds from the sale, or a valuation cap. And the cap is it's a very complex mathematical formula, and I would say if you're really interested in this to Google SAFE math, because it's interesting what happens and it's really important that you understand the impact it has on your cap table. But it basically says if that cap, let's say you raise your next round of capital and the cap is, $50 million, you're going to end up with very little value from having been an early investor. And so the cap says, no matter what you raise at in the next round, we're going to put a cap on it so that we know that we're going to benefit at least some extent to have taken a risk on you at this early stage. So the cap and or discount are the only terms that are negotiable, and otherwise there's a form of SAFE on ycombinator.com and you print it out and you use it. And it saves a huge amount of legal fees. Now there are a couple of other terms to the SAFE. When people invest quite a bit of money, there are certain rights. It's called a side letter, and that's also a form. It's also on Y Combinator where they get certain other rights. For instance, they want to know when you raise that next round that they can buy their pro rata share of that preferred stock so that they maintain a certain ownership of your company. And then certain like extraordinary information rights so they can keep up on, financially, how you doing, what are you doing with their money? And so those are some extra things, but I'll tell you, be very careful because, for instance, I have a client who just started a raise and she sent me a side letter and it had from a potential investor and it had a real lot of special rights for this investor. And she was like, can you please review this and make sure I can sign it? I said, how much is this investor putting in? And she said, 50,000. And I said, it's not market to give all these extraordinary rights. Those are rights you save for your investors who are putting in a real lot of money. And that's relative, but I said to her, I rarely see it for less than $250,000 investment, unless it's an investor who's going to add a lot of value strategically to your company, and you want to make sure that this person or this company or whatever it is represented on your cap table and in partnership with your company and cares about its success. Then that's a different story as well. But otherwise, be careful about giving those special rights to your investors in a SAFE. So that's the very basics of a SAFE. So now you've raised a convertible round and you say, ready to raise my next round of capital. And what most people know about is what's called a Series A preferred stock. And we'll talk about that in a second. And that's, very, very common. But there's this hidden gem that I think is just, something that's a great thing to know about that very few of my clients know about because for some reason it's not talked about as much. It's called Series Seed Convertible Preferred. It's a little confusing because it's not the seed round. Seed round and angel round are typically used interchangeably for that convertible note or SAFE round, and the more like $1 million raise or below. This is actually preferred stock. I think it's really confusing that the people decided to call it Series Seed personally, but be that as it may. Again, so it's sort of a Series A light. Again, what I love is seriesseed.com. The form is right there. The purchase agreement is right there. There's very little negotiation that goes on, saves you a huge amount in legal fees. And it gives the investors in that round, it gives them, it's a price round. So there is a valuation of the company. They typically get a seat on your board of directors. They get a lot of different rights, but nowhere near the rights that a Series A convertible investor gets. And so, you're giving up less, and it's less expensive from a legal perspective, but it still gives them a lot of different protections. And so those are all on the slides, and I'm sure these will be available through the fourth floor. But let's move on to now. So Series A preferred, and this is when people start talking about Series A, Series B, and so these are actually when you're raising $2 to $10 million. I've seen that number creep up, but I don't know where it's going to settle given current economic conditions. And these documents, so these Series A preferred, the documents are on another website called the National Venture Capital Association. So we lawyers all talk about the Nbca Documents. And, again, much more expensive from a legal perspective than a Series C, because there are about 4 30-page documents involved in a Series A. And also you're typically responsible for paying the legal fees of your investors' counsel as well. And at this point, your investors are pretty sophisticated and they're using the big firms for the most part. And so, this is a big step in the evolution of your company. The legal fees are going to be quite large. And in addition, what you're going to give up to your investors is a lot of control. One of the big difference from Series C preferred is this concept of anti-dilution protection. So let's say you raise money on a Series A and you're not quite at your Series B, and this happens all the time, even in great economic circumstances. You're ready to raise your Series B, really take it to the next level, or you're negotiating with a bunch of potential buyers for your company, and there's some really interested companies, but you need a little bit of money. You need a little bridge round. And so you have to do what's called a down round. You have to give those new investors a little bit of better rights because you desperately need this short-term money and you don't have the assets to back up a loan yet. And so you do this down round. Well, your Series A people, they get to take those terms and convert their securities into those same great terms. So your cap table is really impacted, and your rights is that your ownership as a founder gets significantly diluted. So it's a little scary. The other thing is that typically there's multiple board seats, not a majority, but multiple board seats that go with a Series A. And then there's all these different protective rights that basically say you can't do much in terms of, like, you can run your company day to day, excuse me, but you cannot do very much in terms of out of the ordinary course, like deciding to borrow money, hire someone, give yourself, maybe you've been barely paying yourself a salary for years and years and years, and you're like, okay, like now we're rocking. We've got a great company going here, and I want to pay myself a real salary. You need your Series A preferred holders to agree to that. So giving people a raise, there's all sorts of rights that come along with this, and I've seen it. Very often clients go into, or founders go into these negotiations with their Series A investors, and it is so lovey-dovey and great, and we're all so excited, and we're going to take this company to the next level. And then you have a rough couple of quarters, something happens, and they it's not, and a lot of times the investors come down hard, and the founders will say, like, they hate me, they want us to fail, they want to replace me. And I say, like, no, this is not personal, but this is business. You took a lot of money from them, and they don't feel like you're being the proper steward of their money. And so therefore they're going to exercise these rights they have, and they're going to come in and, tell you they don't like how you're running the company in certain ways and say, like, maybe you're out as CEO, maybe we're going to put in someone else, maybe, and so it's really, really, it's a big step to take Series A money. They also get, they get registration rights. So if you go public, they get to register their shares, a lot of different rights. There's this concept of a right of first negotiation. And I'll tell you, this has been, I've been doing this for a long time and I've seen a lot. And one of the things I recently saw, one of my current clients is going through is they had a wonderful investor, really strategic, really important, but this investor did not put in all that much money and negotiated a right of first negotiation. What that basically means is if this gentleman goes to sell his company, they get to jump in and match the sale price. And so what that's doing is potential buyers are saying, like, why would I go through putting an offer together, putting it on the table, paying lawyers to negotiate, doing due diligence on your company, only to know that, when we finally make you an offer, this other investor can swoop in and say, no, we're buying the company instead at the same price. So it's having a really negative impact on him, which I told him, which he was very well aware of going in, but wanted to take the chance because it was a cost benefit analysis on having this investor be involved in the company. So just things to keep in mind. Okay, so let's talk about the law, which is not super sexy, but really important, that's underlying all of this stuff. So in all of these, whether you're selling a convertible note or a SAFE or series, any series of preferred stock, you're selling a security. And so the seminal case we look at is the SEC versus Howey. We call it the Howey test. If someone is investing money in your company and they are really not involved in the day-to-day and they expect you to turn their money into more money, you are selling them a security. And so the federal and state securities laws say, well, if you're selling them a security, then you need to register with the SEC. Registering with the SEC is like the same thing as an initial public offering. It's a hugely time-consuming and expensive ordeal. And so you say, like, wait a minute, I'm just a startup. I can't, so what do I do? So what you need to do is find an exemption from registration with the SEC. And so they're all different. There are exemptions for the kind of securities you're selling. So let's say you're a charity, you're exempt. Let's say you're a bank and you're selling securities, you have an exemption. But most of those are not going to apply to your businesses. And so you're going to want what's called a transactional exemption. So something where the way you're selling these securities is exempt from registration. And there are a whole bunch, but what's going to be most applicable to startups and what you're going to hear is this concept of Reg D. And Reg D comes from this exemption in Section 4.2 of the Securities Act of 1933, which basically says if you're not making a public offering, you're not selling securities, or you're exempt. You're selling securities, but you're exempt from having to file with the SEC. So what's a public offering? Like if you're selling to one investor, no, that's private. There's no public involved there. If you're selling to two, probably not. Three, I don't know. Is that where do you? How many investors can you have and know that you're still sure that you're exempt under Section 4.2? And so the SEC came up with this Regulation D, which we call a safe harbor, which means if you comply with Regulation D, we will deem you to not be engaged in a public offering. So there's a bunch of rules now under Regulation D. And so we'll talk about some of them. So Rule 504 is if you're raising up to $5 million, and it's very simple to comply with. And the reason that I'm not going to talk all about it is that many of the states, you also have to have an exemption under state law, and many of the exemptions of the states don't have a matching exemption. So I'm not going to talk a real lot about 504. The most typical you're going to raise under is called Rule 506B. And Rule 506B says you can have up to 35 non-accredited investors. And wait, let me just check my next slide goes into a little more. No, okay. So, whoops. Sorry about that. I don't know what just happened. Hold on. Go back to where we were. Okay. I think I need to be in current slide. Okay. So, so 506B says, as long as you have no more than 35 non-accredited investors, and now let's talk real quick about what that means. So an accredited investor is someone who has an income of $200,000 in the last 2 years with an expectation of the same in the current year, or $300,000 together with their spouse, or totally separate test, $1 million net worth, exclusive of the value of their principal residence. Those are the most common, but then there are all different additional ones. So you'll, like, if you have an entity that's investing, if it has $5 million in assets, it qualifies. Or if all of its owners are individually accredited investors, then it qualifies. If someone's a registered investment advisor or broker dealer, they qualify. Family offices qualify, venture capital funds qualify. So there's a whole bunch, but the typical are the income or net worth test. So 506B, you can have up to 35 non-accredited investors, and you cannot do what's called general solicitation. So you have to have some relationship already with your investors. You can't go on social media and say, hey, I'm raising money, this is my great company, come invest in me. You'll lose your exemption under 506B. But you can go to, like, it doesn't have to be someone who's been your best friend since kindergarten. It can be someone your lawyer knows, someone your accountant knows, you know, friend of a friend, someone you know, just some type of relationship with that person. And then the other one is 506C, and that came about in 2012, and that's a general solicitation offering. So that here you're allowed to go on social media and say, I'm selling shares in my company, I'm selling safes in my company, you know, come invest in me. And the only thing there is that all of your investors have to be accredited investors, and the burden is on you to confirm that. So with the 506B, you can have someone like check a box saying like, yes, my net worth is $1 million. 506C, you are responsible for verifying that these are all investors are all accredited. And so, you know, what used to happen was in the early days of this exemption, you know, founders would have to say, you know, can you give me your W-2 or your tax return? Like, I need to know that you're accredited. And there was obviously a lot of pushback from investors. And so now there are online, you know, sites that will do the accreditation for you. But that's just really important to know. And then the last one is crowdfunding, which I'm sure everybody's heard all about. And crowdfunding allows people to put in, to be completely non-accredited investors, and they can but there are some requirements, restrictions that make it difficult. So first of all, you can only raise up to $1 million a year. Second of all, you have to use a SEC registered portal. And so there's fees associated with that. And then, you know, there are still caps on how much money an investor can put in, depending on what is their net worth, what is their income. So some stuff to keep in mind. And then the other thing with, go back to the next slide here. So the other thing is that you need to file what's called a Form D with the SEC. So with any of these, you're going to need a lawyer involved. And a Form D is very simple. It's just a disclosure document. It's like 2 pages, and it's just telling the SEC they never are going to look at it unless someone brings an action against you. Just a notice, we're out there, we're raising money. So, okay, now you know all this, and you say, okay, great. Like, I understand that's the law. What do I need to give investors? And some lawyers, many, will say, print the Y Combinator safe off of the website and fill in your cap or discount and give it to your investor, and you're good to go. So That is not my take. My feeling is so I talked about the Securities Act of 1933. There's also something called the Securities Act of 1934. And what it says is that if you are selling a security, you must tell your investors everything that a reasonable person would want to know in deciding whether to invest. And so, if you just give them a deck and you don't tell them things like, we have a really, really big successful competitor in the market. And, but we think we're better. We think we're going to just blow them away. And then you don't, and that investor loses their money. They have an action against you because under the 34 Act, the Securities Act of 1934, they're going to say, wait a minute, if you had told me that you had this huge competitor out there, I would never have invested in your company. And that's, potentially really devastating for your company. So what I recommend is, and there are some caveats to this. There are some venture capitalists that'll say, I'm not signing these additional documents. I'm just going to sign the safe. And that can absolutely be worth it if you're talking to like an institutional investor. The courts are not, again, going to be super protective of them. They know that they're able to do due diligence and protect themselves. They know that they have a lot of money. So you're probably safe with when that happens. But for all the other investors, like more of your angels, friends and family, I would always I do a subscription agreement. And that's a document that's, it's a form, it's 4 or 5 pages. It asks for all these different representations and warranties from your investors. Like, it's got I'm accredited investor, and this is why. I'm not buying these securities, these, shares in your company or these safes to turn around and resell them and create a public market so that you lose your exemption. I've talked to my lawyer. I've talked to my accountant. I know that this is, not going to be a bad thing for me tax-wise, a bad investment for me. I know that this is a startup and I could lose all my money. All those things. I attach to that 2 exhibits. So the first one is your deck or some other in-depth description of the company. So, again, 2-3 pages. This is our business. These are the founders. These are their bios. This is what our cap table looks like right now. Here's our plans for the business, that type of thing. And then the second exhibit, which is the most important, which is a set of risk factors. And these risk factors say, you could very well lose your money by investing. We're a startup. We're going to do our best, but we don't know if we're going to make it. We have this big competitor in the market. The government could place regulations on our product and, or service. And you could lose your money because of, we may not make it because of those potential regulations that we don't know what they're going to be. There's all different potential things that could happen with any business, let alone a startup. And so, we're probably going to need more money than this. And what if we're not able to raise it? So, and then the subscription agreement says, I've read that exhibit B, I've read all these risk factors, and I get it, but I still want to invest. And I will tell you that, I'm knocking wood on my desk. I've been doing this 30 years. I've never had a client be sued, because if your investors sign that document and lose their money and go to hire a lawyer and say, like, I want to sue them, I want my money back, the lawyer is going to say, I'm not taking this case. You're going to lose. I mean, you signed this document that said you knew darn well that this could happen. And so, that's why I feel very strongly about having those documents. Two other like real quick things, and then we'll talk a little bit about some other interesting facets of startup life from a legal perspective. So we'll go in opposite order of the slide. One of them is that there are state laws, as I've mentioned, with each of these things as well. So you have to make sure the laws apply to the states in which your investors reside, and they're really all over the board. So like New York is the one where you have to actually make a filing with the state of New York before you're allowed to even send your deck over to investors. Now, in reality, that doesn't happen, but certainly you cannot give them a subscription agreement or a safe to sign until you've made a filing with the state of New York, and they require that with even one investor. And the fee is like $1,200. I love New York, but you know, New York. With a state like Florida, there is no filing and no fee at all required. You know, where I live, Illinois, hybrid, if you have all accredited investors, there's no filing at all. If you have any that are non-accredited, it's a filing within 15 days after the first sale to an investor in the state, and a $100 fee. And that covers all your future investors in Illinois as well. So it's really all over the board. So you have to make sure to look at where your investors reside. And then the next thing I'll say, and this is you know, really common thing I get from people. Founders will say, oh, I found this company, or a couple of friends I know, or someone I met, and they said they'll make introductions for me to potential investors, and they'll take like a percentage of the raise. If those people are not registered as broker dealers with the SEC, it is a huge problem. I would say that's a giant red flag. Don't just do that. Don't just let them sign an agreement to let them do that, because if they are caught as acting as an unregistered broker dealer, you as a founder could have aiding and abetting liability. And the SEC is really hot to trot on this issue for the last couple of years. And so you have to be really, really careful. Now, if this is someone, so you have to be registered as a broker dealer if you are what's called engaged in the business of raising money for other people. So if this is someone who's like a good friend of yours who, or you know, someone who's like, I think your company is awesome, and I know some really rich people, and I'd love to sort of be compensated for introducing them, but I'm never doing this again. I've never done this before. I just think your company is really special. I adore you. I want to help you. That's not engaging in a business. So that's okay. But there are a lot of, I mean, serious like shysters who go around saying they can do this and are really not legally allowed to do that. There are some groups, I know one group in Chicago here that works with a lot of my clients, and the way that they've structured the way that they get compensated, it's not a flat amount of money that they make or shares that they get in the company for helping sell the securities. And so, you know, it's a fine line that they're walking. They have a very large, well-known firm that's signed off on what they're doing. And so, you know, I always say, like, I'm certainly not going to opine on it, but I feel a lot better about that, at least, than some, you know, just company that contacts you on LinkedIn and says, like, I saw that you've got this great startup, you're probably raising money, I can help you. So things to be careful about. Oh, here's my slide, sorry, on exactly what a subscription agreement is and the two risk factors. So sorry about that. This is just something to think about when you're, if you decide to do crowdfunding, a little bit of something to think about. So it can be very expensive, and I have a client going through this right now. She did a crowdfunding raise, and it was great. It was some really badly needed money before she was able to attract more serious investors. Crowdfunding can be great for getting your name out there, some publicity, but now she's got a cap table with like 140 investors on it. And first of all, those people have the right to, she actually sold stock, like some non-voting common stock. So all those people have the right to say, like, we don't like what you're doing with your company, show us your books and records. Or we want to bring an action as a group of shareholders on behalf of the company against you. Or, you know, there's just a lot of protections built in for minority shareholders in companies. And so, you know, that's one issue. Another is that it's expensive. I mean, you know, if you need certain documents signed, you want to enter into a shareholders agreement to make sure people aren't transferring your shares to people you don't want to be co-shareholders with you. You know, you have to go out to all these 140 people and get them to review stuff and sign it. I mean, it's administratively burdensome and expensive. And then the last point, and I said this earlier, is that a sophisticated investor is going to know that a later stage venture capital investor is going to be really unhappy with you having this huge cap table because of those headaches, because of the cost and potential headaches of having all these investors. So just something to think about before you do, a crowdfunding raise. And a couple other just, sort of tips and tricks. When you're issuing stock to founders, and this is true actually for early service providers too, you want to incentivize them, you want to thank them for what they've done and give them a little stock in your company. What you typically give them and founders is restricted stock. And so restricted stock means you own the stock as a founder, you can vote it. If the company paid dividends, which no startup is going to do in the beginning, you'd be entitled to those. It's yours. However, if you leave the company for some reason before it vests, you lose those shares that have not yet vested. So a typical vesting period is 4 years. And then it has what's called a 1-year cliff. So after 1 year, 25% of your shares usually vest, and then monthly for the next 36 months. Now, a lot of my clients will come to me and say, are you kidding me? I've been doing this business for 5 years, or less, 2 years all in. And, I don't want to go back to not really truly owning my stock. And so I'll say, if your investors can tolerate it, we can start with, half of 50% of your stock already being vested because you've been all in for 2 years. So none of this is set in stone. This is just what most venture capitalists like to see. And so what happens is, anything vested, if you leave the company, if you're fired, if, God forbid, death, disability, you lose whatever has not yet vested and you keep the rest of your stock. One of the things that I recommend to co-founders is that you also have an agreement that says the company has the right to buy back the stock that is vested, but that would be at fair market value. There are co-founders who are like, no, and service providers who are sophisticated who say, no, if I'm going to put in the time and end up with vested shares, you're not buying it back. That's mine. And I get that, but again, just, things I've seen through the years. So I had a very, very early client that came to me, and I used, which is still my starting point. There are certain big law firms that have sets of founders documents online, and a lot of them are great, and they save a huge amount of money and time. So the particular firm documents that I was using, this was my very first founder, did not have this buyout, still don't have this buyout right built in of vested shares. And so this gentleman hired a chief sales officer. He thought, she's taking this company to the next level. She's the greatest thing in the world. And she did a great job for a year, 25% of her stock vest. And then she kind of disappeared and she wasn't helpful anymore. And he said, I'm going to terminate her. She's not helping me. And then, so he does that, but now they're not on good terms. And she's got a substantial, he had given her 10% and 25% of that invested. For the next 5 years, she was such a problem for him. She came to every annual meeting. Now, companies are required to have annual meetings, but in practice, when you're a startup, it's a one-page consent that your lawyer's paralegal puts together. But no, she wanted to be at the meeting. She showed up at every meeting. I want to see your financials. What are you doing? I disagree. I don't like how you're running the business. So a real thorn in her side. So now I just always let founders know that I recommend, you don't have to, it's your business, but having the right to buy back stock. The other thing you should know about restricted stock is that you have to make sure to file what's called an 83B election. This is so important. If there's one thing you take from this, write that down. So when you have stock that vests over time, you get taxed on the value of the stock as it vests. So if some of your stock is investing for 3 years, hopefully your company is going to be worth a lot of money in 3 years. And then you're going to get a tax bill for the value of your shares at that time. And you're going to be really unhappy about it. If you file what's called an 83B election, very simple 1-page form, you literally just mail it to the IRS. It's due within 30 days after the date of issuance, the first day that the stock is issued. Okay, and there's no there's no what am I trying to way around that. I mean, it's 30 days period, end of story. By filing that form, you lock in the value of all your shares for tax purposes at the value on the date the shares were issued in the first place. So that's no value, therefore no taxes, because you're a startup and under the applicable laws, you don't have any value yet, most likely. And so you're going to save a huge amount of money in taxes. And so that's really, really, really important. Couple other quick tips, because I know we're almost out of time. You know, if you have a co-founder and you're 50-50, you must have an agreement in place with your co-founder as to what happens if it doesn't work out between the two of you. You know, if you think of like 50% of marriages end up in divorce, this is a marriage, and I would say 80% end up in divorce at some point. And not something you want to hear. I mean, I hate being the, you know, the big bad lawyer who has to come in and say, like, your relationship may not work out and you've got a plan for that. But it's so important, because a lot of times I've seen businesses just be stuck. And because there's no way to resolve the dispute between you unless you go to court. And that's a real lot of time and emotional anguish. And so, you know, that is, you know, a really big deal. And then the very last thing I'll say is that when you give people, when you want to incentivize your employees with equity, typically in the very beginning, because there's no value, you can give them those restricted shares. Once your company, you know, you're 1, 2, 3 years in, and you've got some value to your company, those people are going to get taxed if you give them stock, and they're not going to be real thrilled about it. And that's when companies typically switch to stock options, which give them the right to buy into your company, and therefore they're not taxed when they get a stock option. They're not taxed till they exercise it and actually own shares in your company. And they typically don't do that until you're selling the business. And so they're getting a whole lot of money back, hopefully, for their stock, and they can afford to pay the taxes then. And so that was a huge amount of information packed into an hour. I hope it was helpful, and I really can't wait to hear the questions that you have to throw at me, and I can go into a lot more depth on some of this stuff on Thursday.
Thank you so much, Leslie. I know we're not doing questions, but real quick, was it possible for you to just speak on the exemption that should be relied on for very early investors for safe notes and convertible notes? I guess it's called the Type 4A2.
That's the section. That was the section 4.2 that I was talking about, which is you're doing a private offering, and so you use Regulation D. And, you know, usually Rule 506B under Regulation D to make sure that you're not conducting a public offering. You're just making a private offering. So,
got it.
So Section 4 means exemptions. A is one of the subsections, and then 2 is the private offering one.